So the law changed in March 2022, and it's now an offence to hold a mobile phone whilst driving. Police don't need to prove that you were using the phone for any particular reason, like they used to. They now only have to show that you're holding the phone. Now, there are a few ways of avoiding a conviction for an offence like this, and that's quite important because the offence carries 6 points and a financial penalty. And for any driver, even with a clean licence, 6 points can cause problems, not least for insurance, etc. But you don't want to get 12 points on your licence in that 3-year period, because then you're looking at a 6-month driving disqualification. So if 6 points can be avoided, then it may make sense to try. Now, one of the most common defences, one of the most effective defences, is that the device that you were holding, whilst it might have been electronic, it wasn't a mobile phone. Now, it might have been an iPod, an MP3 player. That might resemble a mobile phone or look like a mobile phone to somebody who stood next to the vehicle or driving past or walking past, but it may not have been a mobile phone. If we challenge this case on the basis that it wasn't a mobile phone that you were using, then the burden will fall on the prosecution to prove that it was. And they, of course, must prove beyond all reasonable doubt that the device was a mobile phone. And that can be difficult for obvious reasons, particularly if they didn't seize the device or take photos of it or ask you questions about the device. It may be difficult to prove that it was actually a mobile phone. So an MP3 player, a sat-nav, a video recorder, a voice recorder of some kind may not necessarily constitute a mobile phone, and therefore you wouldn't be guilty of the offence. One other common way that offences like this will fail is on prosecution disclosure. So if at any point you decide to plead not guilty, then the prosecution have to serve additional evidence. And this doesn't just apply in mobile phone cases. In any criminal case, if you enter a not guilty plea, the burden falls on the prosecution to prove that case beyond all reasonable doubt, and that's the same standard of proof for a murder offence as it is for a mobile phone offence. And the only way they can do that is to provide evidence. And they also have a responsibility to serve evidence under the Criminal Procedure Investigations Act, I suppose under the Human Rights Act as well, under the Criminal Procedure Rules. And there'll be various court directions that may say when and what kind of evidence the prosecution have to serve. In a lot of mobile phone offences, in my experience, just dealing with these cases and challenging them day to day in and out of courtrooms, prosecution don't always do a very good job of providing evidence. They miss deadlines, they might not serve the correct evidence, they may not understand what kind of evidence needs to be provided depending on the defence arguments that we're using. But the short of it is, if the prosecution can't provide the correct evidence in time, then you shouldn't be convicted of the offence. You shouldn't be convicted of a crime where you've not had the chance to look at the evidence against you, because that could never be considered a fair trial or a fair hearing. And it's usually because of delays, administration problems, probably staffing shortages. A lot of prosecutors seem to be on sick leave, as do police officers, frontline services. So all the day-to-day practical problems that the prosecution face when trying to deal with these low priority cases seems to me to have a massive impact on how they're prosecuted. And so if they're not serving evidence in time, then you would usually win the case for that reason. Now, as far as sentencing is concerned, it is an offence that carries 6 points and a financial penalty. Generally, the 6 points won't change, even if you're convicted at a later stage. And this is one argument for not accepting the conditional offer. If you receive a conditional offer that's asking you to accept 6 points and a financial penalty, and you accept that, then that's what you'll get, 6 points and a financial penalty. If instead you decide, well, I'm going to challenge the allegation because I want to avoid a conviction, I need to keep my licence clean for work purposes, or you might already have points in your licence and therefore can't risk any more, and so you challenge the case, you plead not guilty, and let's say things don't work out. All the evidence is provided in time and they've got what they need to achieve a conviction. Now at that stage, you can still only ever receive 6 points, like you would do anyway if you accepted the conditional offer. But there may also be an alternative that's available to you, and it's what's called a basis of plea. And again, this approach works really well in cases like these that I deal with, when all the evidence checks out. So if they've got what they need, we don't then just plead guilty to the mobile phone offence. Instead, we approach the prosecution and we offer a guilty plea to a slightly different offence called not being in proper control of a motor vehicle. And the going rate for that offence is 3 points as opposed to 6. Now, if the Crown accepts that, and they usually would do for various reasons, then you get 3 points on your licence, you don't get the 6, and that can make a massive difference in terms of the number of penalty points and also whether or not you're at risk of a driving disqualification. So if you've got any questions about a mobile phone offence, then please get in touch. We do offer free initial advice over the phone, and you'll find all our details on our website. Thank you.